4:47 a.m., April 3rd, 2026. Pensacola, Florida. Two unmarked U.S. Marshals vehicles turned onto Cordova Park Road and cut their headlights. A third vehicle, a black Ford Expedition, pulled into position at the end of the block. Inside, 7 federal marshals, 2 NCIS special agents, and 1 folder. The folder contained a warrant. The warrant had taken 34 years to arrive. The house at 1412 Cordova Park Road was a single-story brick home with a well-maintained lawn and a wooden cross mounted beside the front door. A truck registered to Garland Pruitt sat in the driveway. Pruitt, age 67, had lived here for 19 years. He was a deacon at Covenant Grace Fellowship on North 9th Avenue. He coached youth baseball at a community field 3 blocks east. His neighbors described him as quiet, generous, the kind of man who brought food to funerals. Inside that folder, a DNA match. A strangled sailor. A conviction from 1989 that belonged to someone else. The marshals moved to the front door at 4:53 a.m. Standard 2-column formation. 2 agents flanking the entry, 1 at the corner of the house covering the side yard, 2 more on the driveway and the registered truck. The porch light was off. A motion sensor on the garage did not trigger. The neighborhood was entirely still. Garland Pruitt did not answer immediately. When he did, he was wearing a bathrobe and holding a glass of water. He looked at the badge, then at the warrant, then back at the badge. He did not say a word. The agent read the charges aloud in the doorway. Murder in the first degree. Federal jurisdiction under the Uniform Code of Military Justice. Obstruction of a federal investigation. 1 count of evidence tampering. Pruitt was handcuffed without incident. He was placed in the rear of the expedition at 5:01 a.m. He did not speak again until he was formally processed at the federal courthouse in Pensacola at 7:34 a.m. 34 years earlier, another man had been handcuffed for the same crime. That man's name was Marcus Teel. He was 61 years old. He had spent more than half his life in a Virginia federal penitentiary for a murder he did not commit. The file had been closed since 1997. The warrant had never expired. This is what happened in between. November 18th, 1989. Naval Station Norfolk, Virginia. Building 4 Bravo. Petty Officer 2nd Class Dana Ruiz, age 24, was assigned to the Administrative Support Division attached to Fleet Anti-Submarine Warfare Command. She had been in the Navy for 3 years. She had 6 months remaining on her contract. Her records indicated no disciplinary history. Her last fitness report rated her above average in every category. Dana Ruiz had grown up in Laredo, Texas, the second of 4 children. Her mother worked as a school librarian. Her father was a licensed electrician. She had enlisted at 21, originally planning to use the Navy's education benefits to study nursing after her service ended. She had already submitted a preliminary application to a community college program in Virginia Beach. She had bought a used car 3 weeks before her death, a 1987 Honda Civic in pale blue, and had told a barracks friend she planned to drive it home to Texas for the holidays in December. None of that happened. At 0610 hours on November 18th, 1989, Petty Officer 1st Class Althea Simmons entered the berthing area of Building 4 Bravo and found Dana Ruiz unresponsive in her bunk. Ruiz was lying on her back. A cord from a standard-issue footlocker had been looped around her neck and tightened. She had been dead for an estimated 2 to 4 hours. Naval Criminal Investigative Service was notified at 0623. The crime scene was secured at 0641. The senior investigator assigned was Special Agent Vernon Caulfield, an NCIS agent with 11 years of experience based at the Norfolk field office. Caulfield's initial assessment noted ligature marks consistent with manual strangulation followed by secondary application of the cord. Time of death was estimated at approximately 0300 to 0400 hours. The scene showed limited signs of forced entry and no evidence of robbery. Ruiz's wallet, identification, and personal electronics were undisturbed. 2 items were collected from the scene that would matter enormously decades later. A hair sample recovered from the victim's uniform collar, and a second hair sample found inside a standard evidence envelope that was misfiled in a secondary storage box rather than entered into the primary case record. Neither was tested in 1989. DNA technology had not yet been integrated into routine naval criminal investigations. The samples were catalogued, 1 correctly, 1 incorrectly, and sealed. The investigation moved quickly towards circumstantial evidence. Petty Officer 3rd Class Marcus Teel, age 27, had been seen arguing with Dana Ruiz 2 days before her death. 2 witnesses confirmed the argument. The dispute was reportedly personal in nature. Teel could not account for his whereabouts during the estimated window of death. He said he had been sleeping. He had no corroborating witness. Teel was interviewed 3 times over 6 days. He maintained consistent denials throughout. There was no physical evidence connecting him to the scene. No fingerprints, no DNA, no material trace. The prosecution's case rested on proximity, motive, and the argument witnessed by 2 sailors. What was not presented at trial? A statement from Petty Officer Brenda Castillo, a junior sailor assigned to the same barracks. Castillo had told investigators that on the night of November 17th to 18th, she observed Master Chief Petty Officer Garland Pruitt exiting the Building 4 Bravo berthing corridor at approximately 0340. She noted the time because she had been awake with a toothache and had checked her watch. Castillo's statement was entered into the investigative file and marked, "Assessed unreliable." Witness could not confirm specific corridor, citing unverified. The investigator who made that assessment was Special Agent Vernon Caulfield. Garland Pruitt was Caulfield's direct commanding officer. Marcus Teel was convicted on February 14th, 1990. He was sentenced to life imprisonment. He was 27 years old. I spent time going through the original trial transcript. It runs more than 400 pages. There is one paragraph on page 312, buried in a procedural footnote that reads almost like a clerical error. It describes the secondary evidence envelope, the one containing the misfiled hair sample, as collateral material, pending entry, status unresolved. That notation was made in 1989. It was never updated. The envelope sat in a Norfolk evidence storage facility for 34 years without anyone noticing that pending entry had never become entered. The CODIS audit that changed everything was not targeted. It was routine. In February 2026, NCIS initiated a systematic review of legacy evidence submissions from pre-2000 cold case files as part of an internal compliance process under the Department of Defense's Unresolved Military Justice Cases Initiative. The program had been running since 2023 and had processed thousands of files from installations across the country. The Norfolk cold case batch was assigned to Special Agent Karen Vasquez at the NCIS field office in Quantico, Virginia. Vasquez, 39, had worked cold case review for 6 years. Her role was not investigative in the traditional sense. She processed paperwork. She cross-referenced catalogue numbers. She flagged anomalies. On February 6th, 2026, Vasquez encountered the Dana Ruiz case file. The primary hair sample, the one correctly catalogued, had been entered into CODIS in 2004 as part of an earlier, incomplete audit. It had returned no match at that time. Vasquez's task was to confirm the entry status and update the record. What she noticed was a catalogue discrepancy. The primary evidence log referenced 2 hair samples. CODIS showed one, the secondary envelope, marked collateral material, pending entry, status unresolved, had never been submitted. She flagged it. The physical envelope was located in long-term storage at Naval Station Norfolk's evidence facility on February 11th, 2026. It had been sealed since 1989. The seal was intact. A supervising technician photographed the envelope before it was opened, per cold case evidence protocol. The exterior showed no signs of tampering. The catalogue label, handwritten in blue ink and partially faded, still matched the 1989 entry log number exactly. The hair sample inside was submitted for STR profiling on February 13th, 2026. The first sample, the one already in CODIS, returned a match on February 19th, 2026. The second sample was still being processed. The CODIS hit on the first sample did not come back to Marcus Teel. It came back to Garland Pruitt. Vasquez flagged the match within the hour and escalated to NCIS Special Agent in charge, Daniel Okafor at the Quantico field office. Okafor reviewed the original case record that same afternoon. Within the first 2 hours, he identified 3 specific problems with the 1989 investigation: the discrepancy between the 2 hair samples, the dismissed Castillo witness statement, and the relationship between the assessing investigator and the individual whose alibi had never been formally requested. By evening on February 19th, Okafor had convened a review team: 2 NCIS senior investigators, a forensic DNA specialist from the Naval Criminal Investigative Service Laboratory in Linthicum, Maryland, and a JAG officer assigned to coordinate with the Department of Justice's Conviction Review Unit. The second hair sample returned its STR profile result on February 21st, 2026. It also matched Garland Pruitt. Combined probability of a false match, 0.03%. The forensic laboratory's official report put it another way: 97% certainty of origin, 2 samples, same source, 0 connection to Marcus Teel. And Teel had been in federal custody for 34 years. Here's what's most surprising about this case. It isn't the DNA. DNA exonerations happen. The database catches what the original investigation missed. That mechanism, however slow, functions. What's surprising is that Brenda Castillo's statement, which, if credited, would have directed investigative attention toward Pruitt in 1989, was never subject to independent review. Not during Teel's appeals. Not during the 1994 review of his conviction request. Not during the 1997 case closure. Castillo was interviewed once. Her statement was dismissed by the one person who had the most reason to dismiss it, and no one examined that relationship for 34 years. The standard version of wrongful conviction cases is that the system missed something. Here, the evidence suggests the system was steered. The NCIS review team located Brenda Castillo in March 2026. She was 57 years old and living in Raleigh, North Carolina. She had left the Navy in 1991. She confirmed her original statement in full. She confirmed the time. She confirmed the corridor. She said she had told Agent Caulfield and had been told her account was not strong enough to use. She had not been contacted by investigators since 1989. Investigators spent 2 hours with Castillo at a federal building in Raleigh on March 9th. She was composed throughout. She brought a folder of her own. Personal notes she had written in the years after the trial, kept in a shoebox in her closet. The notes were not detailed. They were fragments. Dates she remembered. Names. A single line written sometime in the mid-1990s that read, "Teel was convicted. I don't understand why no one listened." Those notes entered the prosecutorial file as exhibit supporting material. Agent Caulfield had retired from NCIS in 1998. He died in 2014. Vernon Caulfield could not be charged. Garland Pruitt could. What this case reveals is the institutional structure of military investigations at that time. Caulfield was a senior agent. Pruitt was his commanding officer. The formal hierarchy of a military installation created a conflict of interest that no procedural safeguard identified. There was no independent review of Caulfield's witness assessment. There was no second agent. There was one investigator, one dismissed statement, and one man sentenced to life on circumstantial evidence that would not survive a modern evidentiary standard. The formal investigation of Garland Pruitt opened on March 2nd, 2026. The lead agents were NCIS, Special Agent Daniel Okafor and Special Agent Rebecca Morrow, assigned from the Department of Justice's Cold Case Prosecution Unit in Washington, D.C. The case was complex from the outset. Pruitt had retired from the Navy with a commendation medal in June 1990, 6 months after Teel's conviction. He had lived without law enforcement contact for 36 years. There was no financial trail, no flight risk indicators, no known co-conspirators. The evidence package was the investigation. 2 DNA samples, 1 dismissed witness, 1 structural conflict of interest that had gone unexamined for 3 decades. Okafor and Morrow spent 3 weeks building the prosecutorial file. On March 18th, they travelled to Virginia Federal Penitentiary in Haynesville to interview Marcus Teel. This meeting was not publicised at the time. Teel, 61 years old, met with the agents in a standard interview room. He had been incarcerated since February 1990. He had filed 4 separate appeals, all denied. He had a file of correspondence with 3 different Innocence Project organisations dating back to 2003. The agents told Teel what they had found. They did not make promises. They told him the DNA results and the reopened witness statement were being reviewed by the Department of Justice. Teel listened. He did not cry. He asked 2 questions. Who was the match, and what happened to Brenda Castillo's original statement? He remembered Castillo. He remembered that she had told him, after the trial, that she had tried to say something. He had not known what she had tried to say. Now he did. Put yourself in Marcus Teel's position for a moment. 34 years in federal custody. 4 rejected appeals. And then 2 federal agents sitting across a table telling you the DNA that was never tested placed someone else at the scene. Someone you knew. Someone who had been there, on that station, in those halls, while you sat in a cell. Try to work out what that conversation feels like. 34 years. That is 12,410 days. More time than most people spend in any single phase of their life. The investigation hit its first serious complication in late March. The Department of Justice's Conviction Review Unit determined that Pruitt could not be charged solely on the DNA evidence without a supporting evidentiary structure establishing presence at the scene. The DNA placed him in contact with the victim's uniform. It did not, by itself, place him at the scene at the time of death. The Castillo statement was critical, but Castillo had provided a verbal confirmation 34 years after the fact. Defense attorneys would argue memory degradation. The the prosecution needed corroboration. Okafor's team requested the full archive of Building 4 Bravo administrative records from 1989 from Naval Station Norfolk's Historical Archives Unit. The request was logged on March 22nd. The archive unit responded 6 days later. The relevant records, barracks access logs, duty rosters, watch schedules, had been digitized as part of a 2017 records preservation initiative. Watch schedule records for November 17th to 18th, 1989, showed that Garland Pruitt had been listed as the duty officer on call for Building 4 Bravo that night. His presence in or near the barracks was not only plausible, it was formally scheduled. This detail had been in the administrative record since 1989. It was never introduced into the original investigation. Okafor's team also identified a second witness, independent of Castillo. A retired Navy petty officer named Harold Vance, now 72 and living in Beaumont, Texas, had served on the same station in 1989. In a voluntary interview on April 1st, 2026, Vance said that in the days following Ruiz's death, he had seen Pruitt speaking privately with Agent Caulfield outside the administration building. At the time, Vance had thought nothing of it. In 2026, in context, it read differently. Vance had not been interviewed in 1989. He was not on the original witness list. Okafor called the U.S. Marshals Service Office in Pensacola on April 2nd, 2026. The warrant was signed by Federal District Judge Marina Scholl at the Northern District of Florida Courthouse at 11:47 p.m. The warrant team staged at 4:15 a.m. on April 3rd. Garland Pruitt was taken into federal custody at 5:01 a.m. Here is the detail that stuck with me when I went through the arrest documentation. The agent's report notes that when the charges were read in the doorway, Pruitt's first physical response was to look past the agents toward the street, not at the warrant, not at the badge, at the street. One of the agents noted this in the written report. It was not analysed. It was just observed. Here's an unpopular opinion. The length of time Teel spent in prison is not the most troubling part of this case. The most troubling part is that Castillo reported what she saw to the right person and was dismissed within the legitimate chain of authority. She did everything correctly. She came forward. She told an investigator. And the investigator had a structural reason to ignore her. If there had been a second agent, standard protocol in most modern civilian homicide investigations, that conflict would have had nowhere to go. The failure is institutional. It was always institutional. And Teel served the sentence. What would you do with that if you were Castillo? If you had tried to tell someone and watched a man convicted anyway? Comment below. We read everyone. Marcus Teel's release was formally authorised by the Eastern District of Virginia Federal Court on April 9th, 2026. The order vacating his 1990 conviction was signed by Chief Judge Patricia Holloway at 2:14 p.m. It cited the DNA evidence, the newly surfaced witness statement, the duty roster records, and the previously undisclosed conflict of interest in the original investigation. Teel was released from Virginia Federal Penitentiary at 4:37 p.m. on April 9th, 2026. He walked out in a grey jacket provided by an innocence advocacy organisation that had taken on his case in 2024. He was met in the parking lot by his sister, Loretta Teel Haynes, who had driven from Richmond. He had not seen her in 4 years due to COVID visitation restrictions and limited family travel resources. No one from NCIS was present. No one from the Department of Justice attended the release. The formal legal machinery had done its work. Teel's departure from custody was administratively noted and closed. He gave no press statement that day. He asked to be driven to a restaurant. He ordered a cheeseburger and a glass of orange juice. His sister told the advocacy organisation's communications officer, who later published a brief account, that Teel spent most of the meal looking out the window at the parking lot. Garland Pruitt's arraignment took place on April 11th, 2026 at the federal courthouse in Pensacola. He entered a plea of not guilty. His defence attorney requested that the DNA evidence be subject to independent retesting. The motion was granted. The independent laboratory results, returned on May 7th, 2026, confirmed the NCIS laboratory's findings, 97% certainty of origin. Both samples. Pruitt remains in pre-trial detention. Trial date has been set for October 14th, 2026 in the Northern District of Florida. If convicted on the first-degree murder charge alone, Pruitt faces a mandatory life sentence under federal military jurisdiction statutes. He is 67 years old. Here is where the numbers land. Marcus Teel served 34 years and 54 days from conviction to release. During that time, he filed 4 appeals and corresponded with 3 innocence organisations. He spent nearly half those years before CODIS even existed in a form that could have helped him. By the time DNA review was technologically available, the second sample. The one that mattered was misfiled in a secondary storage box, catalogued with a notation that read status unresolved and left there. The evidence needed to clear Marcus Teel existed in 1989. It was collected. It was sealed. It sat in a Norfolk storage facility while Teel's appeals were denied, while his sister aged, while the investigators who built the case against him retired and died. Brenda Castillo is 57. She remembers what she saw. She has never publicly said whether she continued to think about it over the years. The advocacy organization's report noted she asked only one thing of the investigators when they contacted her in March 2026. She asked whether Teel knew she had tried. He does now. What remains unresolved? The role Vernon Caulfield played in the 1989 investigation cannot be formally adjudicated. He is dead. His decision to dismiss Castillo's statement and his relationship with Pruitt are documented and acknowledged in the Department of Justice's formal case review. They will be introduced as background context in the prosecution of Pruitt, but Caulfield will not face charges. There is no mechanism for that. Harold Vance's account of the conversation between Caulfield and Pruitt outside the administration building in November 1989 is in the prosecutorial file. It is not independently corroborated. It will likely be challenged in court. Whether Pruitt ever formally acknowledges what happened in Building 4 Bravo on the night of November 17th to 18th, 1989, is unknown. His attorney has indicated a not guilty posture will be maintained through trial. Pruitt has made no public statement. Will this trial produce a conviction? Comment why yes or no. We want to know where you stand. If you want to follow the Pruitt trial when it opens in October, and there are more cases in this file series we haven't covered yet, subscribe now. The Warrant Division doesn't close when the arrest is made. It closes when the court does. The case against Gull and Pruitt is built. Marcus Teel is free. The watch schedule that placed Pruitt in that barracks in November 1989 was in the archive the entire time. No one pulled it. Not in 1990. Not in 1994. Not in 1997. 34 years in a box. Same as the evidence.